Section 437 contains provisions for grant of bail to a person who is accused of a non-bailable offence. Which offence is non-bailable? An offence is non-bailable if it is so described by the first schedule of CrPC. If it is described there as non-bailable, we call it as non-bailable. An important question which we now attempt to answer is a non-bailable offence really non-bailable? And the answer is an emphatic no. In fact, the term non-bailable is a misnomer and misleading. It must be emphatically noted that every non-bailable offence is actually bailable, but under certain conditions and circumstances. In this section, we will see what are those situations in which bail can be granted in a non-bailable offence and by whom. In this section, we are dealing with a court of the magistrate only, a court other than a high court or court of session, that is a magistrate's court. And we are also dealing with those cases where a person is arrested or detained without warrant by an officer in charge of a police station. In every case where a person is arrested or detained by a police officer, or where a person appears or is brought before a court, where the court is the magistrate's court, on charge of having committed a non-bailable offence, he may be released on bail. This section says every person who is accused of a non-bailable offence may be released on bail either by the officer in charge of the police station or by the magistrate. So yes, very clearly, bail may be granted in every non-bailable case. The discretion lies with the magistrate or with the police officer who is in charge of a police station. The bail under section 437 is not a matter of right. The accused is not entitled to the bail. It is the discretion of the police officer or of the court. However, this discretion of the court or the police officer is taken away by two exceptions to this first subsection of 437. Which are those two situations where the discretion of the police officer or court is taken away? This is the first exception. A person accused of a non-bailable offence shall not be released on bail if there are reasonable grounds for believing that he has been guilty of an offence punishable with death or imprisonment for life. When the accused is guilty of an offence which is punishable with death or imprisonment for life, then he shall not be released on bail. This is the first prohibition against release on bail in case of a non-bailable offence. And the second prohibition is applicable to a repeat offender. This exception says a person accused of a non-bailable offence shall not be released on bail if this offence is a cognizable offence and he had been previously convicted of an offence punishable with death or imprisonment of 7 years or more. So this applies to that offender who had been previously convicted of a serious offence punishable with imprisonment of 7 years or more. In that case, bail shall not be granted to him. Or if he had been previously convicted on 2 or more occasions, on each occasion of a cognizable offence which was punishable with imprisonment of 3 years or more, and total being not less than 7 years. In both these situations, he shall not be released on bail. So the general provision of 437(1) is that every person accused of a non-bailable offence may be released on bail at the discretion of the magistrate or at the discretion of the police officer concerned. However, in two specified situations, he shall not be released on bail. These are the two exceptions to the general rule laid down in 437(1). But then, there are exceptions to these exceptions also, which means even in these two exceptional circumstances, bail may be granted under some circumstances. What are these? The first exception to both these exceptions is that the magistrate may direct that a person in clauses 1 and 2 be released on bail if such person is under 16 years of age, or is a woman, or is sick, or is infirm. So every person under 16 years of age, every woman, every sick or infirm person can be released on bail even if he is falling under any of these two clauses 1 and 2 which we just now discussed. So, if a woman is accused of committing a murder, let us say, it's a non-bailable offence, it's a cognizable offence, and the offence is such which is punishable with death or life imprisonment. So, when a woman is accused of committing a murder, under the first exception, she may not be released on bail, but under this provision, she may be released on bail. But here the difference is that here only the court can give this direction. Under the normal provision of 437(1), bail may be granted either by the court or by the police officer in charge of the police station. Then there is a prohibition. The provision is that any person accused of such offence which is punishable with death or life imprisonment shall not be released on bail. This prohibition is lifted here in respect of these four categories of persons, and bail may still be granted, but the discretion now is restricted to the magistrate only. The police officer cannot release such a person on bail. A woman accused of murder can be released not by the police officer but only by the court. Then there is one more exception to exception 2. Court may also direct that a person under clause 2 be released on bail if it is just and proper so to do for any other special reason. This provision says that the prohibition made by clause 2 in respect of a repeat offender, in respect of a person who had earlier been convicted of a serious offence, he may also be released on bail if the court thinks that it is just and proper to release him on bail for some special reason. Again, it's the discretion of the court. A police officer cannot release a person who had been earlier convicted in terms of clause 2, but the court can release him if the court has some special reason for releasing him. So these are the bare provisions of section 437(1), where first the general rule of releasing a person on bail is there. Then there are two exceptions where a person shall not be released on bail, and then again there are two exceptions where out of those exceptions some persons may be released on bail, but here the release can be ordered only by the court, not by the police officer.